Good day to you and welcome to another Paddocks Club video. Antoinette Brits, an estate agent and relatively new member of Paddocks Club, posted an interesting question today headed Conservatories. She said, an owner enclosed a part of his section with a glass conservatory a few years ago. He is paying full levies as this is part of the extension and the participation quota of his unit includes the glass conservatory, which obviously also has a glass roof. The conservatory is now leaking in places. Am I correct in assuming that this is a body corporate problem and that they must repair the section that is leaking? Well, this question illustrates a very common scenario which can occur based on two different sets of circumstances. Well, let's talk about the first scenario in which the building is designed with open patios or balconies which form part of the sections. At a later stage, one owner decides to close the open part of his or her section, applies to the trustees and is given permission to enclose the open section, perhaps with glass sliding windows or even an aluminium structured conservatory as suggested in this case. In this scenario, the owner is not extending the section at this stage, so there is no creation of new parts of sections or common property in accordance with an amending sectional plan, but merely the placement of new materials, either within, on the boundary of, or outside the notional median line that already exists. The second, different scenario occurs when an owner is given permission by way of a special resolution to extend his or her section, and does so by way of a combination of walls and windows, so as to add to the habitable space within the section. In this case, a new amending sectional plan must be drafted, and this will show the adjusted boundaries of the section, and where the extended boundary is a wall, door, or window, it will comprise part section and part common property, because as you know, the boundaries of a section run through the middle or median of its exterior walls, and also through the centre of any door or window set into those walls. The fundamental difference between the two situations is that in the first, the material that the owner attaches to the section does not automatically become more common property, which must be maintained, repaired, and eventually replaced by the body corporate at its expense. It remains the property of the owner concerned, who could, if he or she wished to do so, in a year or so remove it and restore the section to its original state. In this first situation or scenario, I suggest that when the trustees give permission for the enclosure of the area that's already part of the section, they should make it clear that the material that constitutes the enclosure must be maintained in good order by the owner and his or her successors in title, failing which the body corporate will be entitled to insist that it be removed. In the second case or scenario, the body corporate's agreement to the extension of the section is in itself an agreement to vary the extent of the section and the common property involved. The default position here is that the additional material added beyond the new median lines shown on the amending sectional plan is common property, and it must in future be maintained, repaired and replaced by and at the expense of the body corporate. If the owners want to avoid this natural consequence of their agreement to the extension, which must, as you know, be given by way of a special resolution, they should insert as one of the conditions of that special resolution that a scheme rule be made in terms of section 32(4) of the Act to the effect that the owner concerned and his or her successors in title will be responsible for the cost of maintenance, repair and replacement of the new common property created in the exercise. I think that the point to be emphasised is that the enclosure of any open area that forms part of a section or extends a section needs to be treated carefully, and the financial consequences need to be understood and, if necessary, dealt with. When a section is extended, the owners should consider the effect that this will have on future costs of upkeep of the common property generally, and make whatever arrangements they think are suitable, and which will be agreed to by the owner as part of the process. Thank you for joining me in this video, and I hope it's been of assistance to you.